Good afternoon. This is your air passenger rights update on September 27, 2020. My name is Gabor Lukács. I'm the president of Air Passenger Rights. I would like to start with thanking our volunteers who are at their usual battle stations, Dominic, Martin, Christine, and Terry, who have gotten us through the past few weeks and who continue helping the work of this group to ensure that Canadian passengers are slowly but steadily getting their refunds or getting the money they are owed from the airlines and getting their rights enforced. I would like to first see if we have a good audio and video, and then we can start. Hi, Jeanette. Can I get a thumbs up or thumbs down about audio and video? Okay. We are going to talk today about 4 items: WestJet's new refund policy, a brief update on class actions, some update on what we should be doing in the coming weeks and months in terms of social media and political activism, and the main discussion is about chargebacks, statutory versus internal chargebacks, an issue that has come up a number of times, and I'm hoping that we are slowly but steadily moving toward a guideline for dealing with statutory chargebacks. Let's start with talking about WestJet's new refund policy with respect to European journeys. One thing to remember about this is that although WestJet is portraying it as a new policy and as something that they are doing out of the goodness of their hearts, this is not the case. Refunds for airlines tickets are always mandatory when an airline cancels a flight for whatever reason. It doesn't have to be for a reason within the airline's control. It doesn't have to be a reason due to safety reasons. Whenever an airline cancels your flight and they don't provide you the service that you have paid for, they have to issue you a refund. The reason that this is happening is because the European Union is properly enforcing the laws, unlike Canada, unlike the Canadian Transportation Agency. The European unions and their various enforcement bodies at the state level have made it amply clear to WestJet, perhaps a bit less to Air Canada, that they do have to provide refunds for all cancelled tickets. So on September 2nd this year, 2020, WestJet put out this new refund policy, which is helpful in terms of dealing with your travel agents. It can be also helpful when you are working with a chargeback. If WestJet is trying to dispute a chargeback for a flight that was to or from Europe, or in fact involving any segment with the European Union, then this refund policy is the best proof to say, well, WestJet itself admits that refunds are owed in this situation. So let's just look through this carefully in terms of what this does and doesn't apply to. One word of caution that they are putting out here is that they are not extending this to flights to and from the Caribbean or Mexico, nor do they extend it to Canadian domestic flights. So in terms of the criteria, they are listed here. The flight dates are between March 1st and October 31st, 2020, which is for all practical purposes, all the flights that might be affected by this recent event. They are now saying, which is the correct statement, that you can submit this any date. And they're promising to provide a refund within 2 to 4 weeks. In terms of the conditions, the ticket must contain at least one European Union origin or destination city. So it doesn't have to be starting from the European Union, doesn't have to be ending there, but once you involve at least one flight that has a European Union origin as on one segment or as a destination, that's enough to trigger this policy. Another important clarification is that the flight segments must have been cancelled by WestJet. And they are adding something that I don't think they can add, which is with no flight replacement as a result of COVID-19. So I don't think that they can stipulate that no replacement was offered. The rule under the European Union's regulation 261 of 2004, is that if one segment of the flight has been cancelled, then the entire ticket has to be refunded. To be precise, we are referring here to unused segments of your ticket. So this does not apply to used segments unless those used segments serve no purpose with respect to the passenger's purpose of travel. And the last point is that it applies to all fares and classes of service. They also outline here a procedure for how travel agents can claim those refunds for their passengers, for their clients. So if you have a travel agent who is telling you, well, I don't know how to do it, this document, and in particular this phone number provided, could be a useful tool to provide to your travel agent. The second item of discussion for today is the class action. The class action has been going on in the federal court quite a while, but when you look at it in terms of how long class actions typically take, I don't think that they are doing badly. Actually, the court is dealing with the case quite quickly. As it stands, the class actions certification hearing is scheduled for November 2nd to November 4th, right around the US elections, by the way. What a certification hearing is, it is where a judge decides whether the particular proceeding should be certified as a class action. It is a procedural motion, but the focus of a certification motion is to decide whether it will be the most efficient way of dealing with a particular legal dispute to deal with it through a class action. The class action, on the one hand, saves a lot of expenses and time and resources, not only to the parties, but also to the court. When you have 10,000, or in this case, more like hundreds of thousands of people with a common issue, then having a single legal proceeding for determining the legal rights of the parties and their obligations is an important way to save judicial resources. You don't want 100,000 different cases dealt by different courtrooms, different judges. That would not be efficient. On the other hand, what the court needs to observe and need to consider in such situations is whether there is sufficient commonality in the issues. And I would argue, of course, that in case of flight refunds and chargeback and those refunds and voucher issues, there is a lot of commonality. And the issues that the airlines are trying to raise now in federal court is jurisdiction. The airlines are trying to argue, as I understand, that the federal court does not really have a jurisdiction to deal with those issues that are being raised by the passengers, and therefore they should not be hearing the case at all. I don't think that argument has much merit, but of course, when you're dealing with litigation, and especially with airlines that litigate, they are going to throw every possible argument against you, every possible legal trick to delay the proceeding. So far, I can say that the court has been very good at preventing airlines from delaying the proceeding. They have been very clear that they want to proceed. The court has been clear. There was a change of judges earlier this month in the case management judge, and it seems that both the previous case management judge and the current case management judge are keen on having this matter heard for the certification hearing on November to November 2nd to November 4th. In terms of the next steps, of course, is yet to be seen. After the court is going to hear the certification motion, it may take several months to issue a decision whether the class action is certified. At that point, there is also a question of whether the airlines will want to settle the case or whether they will want to fight it all the way to the Supreme Court. But it will be the first important step toward holding airlines accountable for what they have done to passengers. The other area where we have to come back to our activism after the summer is calling members of parliament. I am troubled by the lack of attention to the issue of refunds lately. It seems that, of course, there are many other important issues, but chargebacks and refunds remain a very significant concern to the traveling community. And I don't quite see how the government would expect to restore the financial situation of the travel industry without restoring faith in its ability to deliver and to honor contracts that have been made. Currently, I would not suggest anyone to travel with a Canadian airline or with any type of business that relies on Canadian airlines, because the Canadian government has shown inability to enforce the law, and by extension, those airlines have shown inability and unwillingness to comply with the law. You don't want to just give away your money and get nothing in return, which is what Canadian travel industry seems to be heading to and has done, and that's what they seem to be continuing as the new norm. So I hope that those who are listening are not only from the passenger rights and the passenger community, but also from the travel industry, and will agree with me that we need to restore faith in the travel industry if we ever want to see the travel industry back to some semblance of normality, to the pre-COVID-19 levels, even after we have a vaccine, which will be in many months from now, and even after we are through with this crisis. So the next step for us is again to start calling members of parliament. I would like to ask everyone who is listening, everyone who is watching, please call your member of parliament again. Tell them that the issues of refunds has not been resolved. It is still outstanding. You want a resolution for yourself. You want a resolution for your community. You want a resolution for Canadians. Give them an earful. Don't just send emails. Make sure that they actually get to speak to you, that they end up spending their time hearing from you and your neighbor and your friends and other people from your community who will tell your member of parliament that the issue of refunds has to be resolved, that it is unacceptable for airlines, any business for that matter, to steal the hard-earned money of consumers and walk away with it. I'm seeing here some questions, so I'm going to address that. Miriam is asking, does this lingo, I believe, WestJet refunds apply if the ticket from Canada to Europe was booked through either Air Canada or Lufthansa, where Air Canada and Lufthansa have booked a segment using WestJet? For example, my ticket to Malta via Lufthansa, the Ottawa-Montreal leg, uses WestJet. Miriam, I don't think that necessarily this would apply, but I would say that because your itinerary, because your ticket involves at least one destination in Europe, it would apply actually. What I would check though is how that WestJet segment was booked. Was it booked as a WestJet flight, or was it booked as a Lufthansa flight operated by WestJet? The two are not necessarily the same. So there are some subtleties there from a legal perspective, whether it was a codeshare type of flight or whether it was actually a flight that was booked as a true to God WestJet flight, part of your itinerary. If it was booked as a Lufthansa flight operated by WestJet, then Lufthansa might be on the hook for having to refund that segment. Actually, when I'm looking at the ticket that you described, if it was booked through Lufthansa, likely they are going to be more reasonable and refund you. Lufthansa is a European airline. Although they have been dragging their feet at the beginning with refunds, they have been bailed out by Germany, by the German state. And my understanding is that they have been reasonable with issuing refunds. I haven't been hearing much complaints about them lately. And there is a question from Carmi. Is this class action suit against all airlines? So Carmi, the class action in federal court is against the 5 major Canadian airlines: Air Canada, Air Transat, Swoop, Sunwing, and WestJet. This federal class action does not include the associated travel companies, tour companies, so it won't involve Sunwing Vacations or Transat Tours or Air Canada Vacations. However, insofar as the flight portion of any such package booked, I would suspect and I would expect that it would be included. Part of the certification process in court is that the judge will have to clearly circumscribe who is and who isn't in the class. David is asking about the court action on the Canadian Transportation Agency's statement on vouchers. We are still waiting to hear from the court what happens there next. The Canadian Transportation Agency brought a motion to have the entire application struck. The Canadian Transportation Agency's essential argument is not that the voucher statement is correct or good, but rather they argue that the court has no jurisdiction to step in, that it is not amenable to judicial review, which is a very interesting legal argument, because by the same token, if tomorrow Health Canada puts out a statement that smoking protects you from COVID-19, and therefore they urge people to smoke as a way to protect themselves from COVID-19, the public would have no way of having that statement removed. So it is a big question how the court is going to read that, how the court is going to treat that type of argument. You may have already heard, and I'm just repeating that with respect to the temporary interlocutory injunction that was denied back in May, we have made an application for leave to appeal to the Supreme Court of Canada, which is still pending. The deadline for Canadian Transportation Agency response to that is sometime in mid-October. We have also been in touch with Democracy Watch, because apparently they also have a leave to appeal case before the Supreme Court of Canada, which raise similar issues of when judicial review is or is not available, which is quite an important issue. Courts have a fundamental role in the democracy to ensure that the executive branch does not overstep their powers, it doesn't overstep the boundaries set to them by Parliament. And so if the courts want to shy away from that role, shy away from actually ensuring that those who exercise statutory power and statutory mandate are not overstepping their powers, then it would be very bad news. Carmi is asking, so there's nothing I can do about my Sunwing vacation package that Sunwing gave me a future travel voucher? Carmi, there's also a class action in Quebec, I believe, which entails the tour operators. But I would say that with respect to those tour operators, I would also very closely look at various chargeback options, which is exactly the next thing I would like to talk about if there are no more questions on this line of issues. I just want to, again, before I go to chargeback, reiterate that this is again high time to contact your member of parliament. Writing an email is great, but pick up the phone, leave messages. If necessary, leave a message every day. Make sure that they understand that you want to talk to them. And as a member of parliament, they have a duty, at least a moral duty, to speak to you as their constituent. Get them to speak to you. Get some of your friends to call them. Get the friends of the friends to call them. Make sure that your MP understands that the issue of refunds and the issue of ensuring that airlines don't get away with theft is very important to you and to other people in your community. I'm going to talk now about chargebacks. We have spoken about it many times, but it seems that the topic is coming back again and again, and for a reason, of course, because this is the one and main way for passengers currently to get back their money before the class action is heard, before further remedies are available. There are two types of chargebacks that exist in the current system. One is what I would call an internal chargeback. It is what you have mostly been doing when you phone your credit card company and tell them, okay, I didn't get a refund, or I didn't receive the services I was contracted to receive, and then the credit card company uses their internal procedures, their internal dispute resolution with another financial institution, because really those transactions are dealt with somehow between your credit card issuer, which is a bank, and the financial institution of the merchant. That's the internal chargeback. The credit card companies and the individual banks possibly that act on behalf of or they are the issuers of those credit cards, the way I would think of them is that they're kind of like a franchise. So MasterCard International allows a certain bank to issue MasterCards, and in exchange that bank agrees to abide by some MasterCard International standards. So MasterCard International in that case sets various standards, various procedures for how the chargeback is supposed to work and what deadlines are applicable, and the bank is at least supposed to follow those. With respect to internal chargebacks, they do have some latitude about how they administer it because it is internal. It is within the institution, within the family of the credit card, between the various financial institutions. There is also a different type of chargeback, which is the statutory chargeback. One of the reasons that credit cards have employed this type of internal chargeback procedures is because the statutory chargebacks are more rigid, more firm, and probably they would prefer dealing with things according to their own protocols, their own procedures than what the law imposes. But just because you weren't given what you were entitled to based on the internal procedure does not foreclose your possibility, your ability, your right for a statutory chargeback. So this is the reason that we are now shifting toward more research and more information about statutory chargebacks, because that is where remedies can be found, and that is where the financial institution can be compelled to actually give you back the money, even if then in the internal procedure they were not that friendly to you. So what we are going to do next is look at some of the statutes, some of the statutes that govern chargebacks, and we are going to look at Ontario, at British Columbia, and Quebec. Ontario seems to have been the most popular province when it came to the survey I ran about how many people are interested in a statutory chargeback guide. So we are going to start with Ontario. So just so that you see, I'm looking at the Ontario Consumer Protection Act, and it has a nice table of contents here, so we can easily find here what we are looking for. And I'm going to just point out various provisions. So let's start with Section 7. Section 7 tells us that the substantive and procedural rights given under this Act apply despite any agreement or waiver to the contrary. In other words, in plain English, it means that even if you sign a contract which says that the Consumer Protection Act doesn't apply or that you don't have a right to a chargeback, you still do. Why? Because the law says that it doesn't matter what kind of agreement you have signed, you still have the rights both procedural and substantive rights given under this act. The merchant, the airline, cannot take away your rights under this act by weaseling in some kind of clever language in their terms and conditions. Let's go back to the top. The next provision which is of interest is section 26, and let's also look at section 21. So sections 22 to 26 apply to future performance agreements if the consumer's total potential payment obligation under the agreement, excluding the cost of borrowing, exceeds a prescribed amount. So the prescribed amount you need to check the regulations is a small couple tens of dollars type of amount. When you purchased a ticket, that certainly triggers this provision. The reason is that you are paying for your ticket in advance and you are not getting the services right away, right on the spot. Section 26 deals with late delivery of services, and it provides you, the consumer, with the right to cancel a future performance agreement any time before delivery or commencement of the services if the supplier does not make delivery within 30 days after delivery date in the agreement, or does not begin performance of his or her obligation within 30 days of the commencement date specified in the agreement, or an amendment commencement date agreed to by the consumer in writing. So just because an airline is telling you, well, we are changing your ticket now from instead of June to October, that doesn't mean that you have agreed to it. It doesn't mean that you have to go along with it. And what is clear from this, that if they don't perform within 30 days, then you have a right to cancel the contract. You may have that right in other cases too, but in that case, it's clear that you have that right. So now what happens with that cancellation? How do you do it actually? That's what we are going to look next. The procedures for consumer remedies are in Part 9 of the Act. So this is no concern because we are not necessarily claiming here unfair practices. The form of notice says that if an act requires a notice to be given to the supplier, the consumer may do so in the form prescribed here. And it is quite liberal. Unless regulations are required otherwise, a notice may be oral or in writing and may be given by any means. In practical terms, I would still suggest giving a written notice of cancellation if you intend to invoke rights under any kind of Consumer Protection Act. And Section 92 says that 94 says that if a consumer has a right to cancel a consumer agreement under this act, the consumer may cancel the agreement by giving notice in accordance with Section 92. The cancellation takes effect when a consumer gives notice. And in terms of the effect of the cancellation, it restores the situation as if the contract would have never been made. So it restores the situation to as if you have never entered into the contract. You no longer have obligation to the merchant, they no longer have obligation to you, except the obligation to refund you. Under Section 96, if a consumer cancels a consumer agreement in accordance with the prescribed requirement, then the supplier, the person who sold you, has to refund the consumer any payment made under the agreement or any related agreement. Part B is not relevant to you because you didn't receive any goods, nor did you delivered them any goods. So it was not like a trade-in for a car. Now, what happens if they don't comply with that obligation to a refund? That's where the chargeback comes into play. A consumer who has charged to a credit card account all or any part of a payment described in subsection 2, which we are going to look at in a moment, may request the card issuer to cancel or reverse a credit card charge and any associated interest or other charges. So in subsection 2, it refers to a payment in respect of an agreement that has been canceled under this act. This is exactly what you need. A consumer may request this chargeback within a prescribed period. Now, the regulations say that I don't have the regulations open right now, but the regulations say that once you have given notice to the merchant has 15 days, 1-5, to issue a refund as required by Section 96. So this refund has to be issued in 15 days of them getting the notice. And so from that expiry of those 15 days, you have 60 days to make a formal request under Section 99 to the financial institution to request that they reverse the charges. So subsection 4 of Section 99 talks about prescribed period. This is where the 60-day comes into play. The regulations also set out what exactly you have to include in your request for a chargeback. You can look it up. I would suggest that if you go for a statutory chargeback, then you follow very, very closely the wording of the regulations and the act. If it says you have to provide XYZ information in your request for reversing charges, you should follow that, and you should do it in writing, keep documentation. And once you send that request within 60 days, the credit card issuer has to, within prescribed period, acknowledge receiving your request. This is 30 days. And if the request meets the requirements of Section 4, which the regulations outline exactly what information you have to provide, they have to cancel or reverse the charges, or after having conducted an investigation, send a written notice to the consumer explaining the reason why the credit card issuer is of the opinion that the consumer is not entitled to cancel the consumer agreement or to demand a refund under this act. So they have to specifically explain which provision, which requirement of this act you don't meet. They cannot just give you a generic response. And if they don't do that, you have a right of action against the credit card issuer for recover the payment and associated interest and other charges. So when they make you these threats of, oh, we're going to charge you interest, you know that actually under the Consumer Protection Act, all those have to be reversed as well. In practical terms, if you get down to this step when you have already made a written request, statutory chargeback, and they are still refusing to provide you with a reversal of the charges, personally, I would suggest clawing back the charges from your next bill. Just refusing to pay it. If you had discussed it before, if it was $1,000, you just pay all your bill except for $1,000, and you inform them that you don't owe the $1,000 because that corresponds to an amount that you have been improperly charged and they have improperly refused to reverse. You deny owing that amount. Once you have a denial of owing an amount, then you can also put them on notice that you suggest that they take it to court and sue you in court if they want to recover the money. under Ontario laws, and most provinces have some form of similar provisions, they cannot contact you for collection purposes. The collection agency cannot contact you, cannot go after you if you told them take it to court, and if you told them that you are disputing the validity of those charges. So don't feel that you are helpless if a credit card issuer is not complying with the law. Actually, they are more helpless than you are, because you can simply refuse to pay, and if they don't like it, they have only one option, which is taking you to court. They have no way of forcing you to pay unless and until they have obtained a judgment from a judge of your province. I'm going to go through the same exercise with respect to British Columbia and Quebec, but the principles are the same. What sets apart Ontario in some ways is that Ontario deals with all future performance contracts, while BC and Quebec are focusing more on distance sale contracts. So contracts which have been made in a way that you're not at the same place, on the same room with the seller. Let's look now at British Columbia. In British Columbia, they have the Business Practices and Consumer Protection Act. It is also a form of consumer protection measure. In some way, it's very, very strong and very good. The most important part that is I would be looking for in any consumer protection statute is whether the merchant seller can contract it out, and the answer is they cannot, because under Section 3, any waiver or release by a person or the person's rights, benefits, or protections under this act is void, except to the extent that the waiver or release is expressly permitted by this act. So what this tells us, that a merchant cannot just contract out the provisions. They cannot just, even if you sign away, oh, it doesn't apply, you can still rely on these provisions. So let's look now at the similar provisions about cancellation of distance sale contracts. In BC2, if there is a delayed delivery, if they don't deliver on time, then you can cancel the contract. If they fail to deliver within 30 days, you can cancel the contract. And once it is canceled, then the merchant has an obligation to issue a refund within 15 days after a notice of cancellation has been given. And they must refund the consumer without deduction of all money received in respect of the contract and in respect of any related consumer transaction. So in BC2, they have clear legislative wording: must refund the consumer. Now, must is very nice, but in practice, we know that some merchants are not rushing to issue a refund. So Section 52 says that a consumer who has charged to credit card all or any part of the total price under a distance sales contract, similar language, if the consumer has canceled the contract under Section 49 and the supplier has not refunded all money as required under Section 50, then the consumer may request the credit card issuer to cancel or reverse the credit card charge and any associated interest or charges. So very much like in Ontario, the difference is that this applies to distance sale contracts. So if you purchase your ticket while physically meeting with a merchant and being in the same location, then it's not clear whether this applies. Now, if you were seeing a travel agent, it is a question to be researched in terms of the law. If you buy a ticket through a travel agent and you went into a travel agent's physical offices, not on the phone or by email, whether it would apply or not, it would have to be researched. what is important about this, though, is that a request under subsection 2 has to include all this information, and you should do it in writing. You have to provide a supplier's name, the date the distance sales contract was entered into, the amount of charge, description of goods or services, reason for the cancellation, date and method of cancellation of the sale of contract. And then after this, the credit card issuer has to acknowledge within 30 days. And if you meet these formal requirements, then they have to actually reverse the charges within 2 complete billing cycles and 90 days within the earlier of these 2. So under BC legislation, the financial institution doesn't have really a discretion to decide whether they want to reverse the charges or not. The only thing that you have to make sure is that you follow these provisions properly to the letter. And last, let's look at Quebec. In Quebec's Consumer Protection Act, I'm going by memory, but it's section, I think, 261 and 262, which say that no person may derogate from this act by private agreement, and no consumer may waive the rights granted to him by this act unless otherwise provided therein. So similar provisions, same flavor, that it is not possible to contract out provisions. Section 54.9 deals with when you can cancel a contract. And contract for transportation, lodging, restaurant services, or for a ticket. If the merchant has not provided the services by the date specified in the contract or later date agreed on in writing, this is already sufficient to trigger your right to cancel the contract. What happens once the contract is canceled? So you exercise its right by sending a notice to that effect to the merchant. And within 15 days following the cancellation of the contract, the merchant has to refund all sums paid by the consumer under the contract. If the merchant defaults on that obligation, then the consumer may, within 60 days following the default, request the card issuer to charge back all amounts paid under the contract. So this is very much like the Ontario system, and I would follow that kind of 15-60 type of scheme. You give notice to the merchant based on the Consumer Protection Act, inform them they have to issue you a refund within 15 days. 15 days passes, on the 16th day, you write to the credit card company, the credit card issuer. In Quebec too, they lay out very clearly what information your request for a chargeback has to contain. And then once the credit card issuer receives a chargeback request, they must acknowledge the receipt within 30 days and make the chargeback within 90 days or 2 complete billing cycles. In Quebec too, the credit card issuer does not have a discretion to decide whether or not they actually want to issue that chargeback. They have to. The law says they absolutely have to. This was just a quick crash course about how statutory chargebacks work. What I'm hoping to achieve in the coming weeks is to have some guides, step-by-step guides of some sorts prepared. It is a lot of work, and one of the difficulties that I'm facing, what I've been talking with a number of volunteers, is how to structure the information well. What I've found over time that we can put out the best possible guide if we think, oh, this is really perfect. But then when comes to users, they read it and they are not understanding it. They are not actually finding what is the next step they need to read. So my hope is that with this round of documents we're going to put out, we will have a bit more time to a bit more opportunity to focus on the presentation of the information. I'm pretty much done with my agenda for today. I just want to reiterate, don't be afraid to refuse to pay illegitimate credit card charges. Charge for services you did not receive is illegitimate. You have to make sure you create a paper trail, but it remains what it is, illegitimate. So if the credit card company wants you to pay, make sure that they go to court. They incur the expenses of having to hire a lawyer, having to pursue this. And if necessary, I would cancel the card just to create a clarity that the balance which is left there is only for an illegitimate charge. So they may try to put, oh, we are going to charge you interest. Well, I can also charge the Pope interest. So what? Just because I take, I have here a small notebook, and I start writing here, the Pope owes me $1,000. And then each month I'm adding there, well, now the Pope owes me another $100 for interest. Does it mean that the Pope will have to pay me? Absolutely not. Same thing applies to credit card companies. Just because they tell you that you owe them something doesn't mean that you have to pay them, doesn't mean that you actually owe them. What matters is whether what they say is recognized by the law, whether a judge is going to agree with them that actually you do owe that amount. If the initial amount over which they are charging interest is illegitimate, any interest charged for it is also illegitimate. If I don't owe money to someone, I don't owe them the interest for that fictional debt either. I realize that you have been very much instilled with the idea that you absolutely have to pay those credit card bills. And normally I would say yes. If you did incur charges, if you go and buy something in a supermarket, if you get goods, of course you have to pay that. We are not thieves, we are not criminals, we are law-abiding Canadian citizens and permanent residents and other visitors here in Canada, or people who are listening. So by no means you should understand me as saying to just blanket refusal to pay your credit card bill. That would be wrong. What I'm saying is that if there is a specific charge, such as for a ticket that you never received the services for, which is illegitimate, don't hesitate to assert that it is illegitimate, follow the proper procedures set out by the statutory chargeback, and ultimately refuse to pay it. Put in the writing that why you are refusing. And if they phone you, just tell them, sorry, I won't pay. That's not that I owe. Don't get into an argument with them on the phone. Just hang up on them. I don't owe this amount. Goodbye. And you put down the phone. You may want to record those calls. The ultimate goal is to convey clearly to your credit card issuer that if they want to see money from you, they have to take you to court. Because once they take you to court, they will not be able to play all these games of, yes, well, this is what the credit card, this is what their airline said, and this is what we said, this is what they think. It comes down then to cut and dry law, which is very simple. You paid for a service, you didn't get this service, therefore you shouldn't be paying for it. They may try to make those threats about we're going to hurt your credit card, your credit rating. I wouldn't be worried about that particularly for a number of reasons. First of all, because there are procedures for dealing with false reports. If a credit card issuer, if a bank reports you as owing an amount that you actually dispute, and they don't inform the credit card, don't inform the credit reporting agency that you are disputing that is already a form of defamation. Even reporting a debt that you dispute is questionable because they have to act in good faith. They have to deal with matters properly. So if you tell your bank, your credit card issuer, take me to court about this, I deny owing you this amount, that already is a good evidence that if they try to put something in your credit report, you can send that letter to various credit reporting agencies and say, I'm sorry, this is a disputed debt, I deny owing this, and please remove this report from my credit rating. And the credit reporting agencies do have a legal duty in most provinces to investigate and act in good faith and ensure that the information reported on your credit report is accurate. So the bottom line is, while it sounds like you're up against those big corporations, you are not alone. There are many people in the same situation, and you should not hesitate to fight back. In the long run, I have very little doubt that we are going to win. It may be a long battle, it may take many more months, but ultimately, I don't believe that it is possible in a capitalistic society that large corporations will simply walk away with consumers' money. I am going to try to answer a few questions. First is by Sandy. Is it too late for you if you already accepted the travel vouchers? They were only offering a small amount of the original price. Sandy, if you were not offered a real refund, I would take the position that it was not a real acceptance. It was essentially them giving you some vouchers without you accepting voucher. Acceptance, for example, in Europe has to be by way of a writing. So again, come back to the idea of the consumer protection laws. Generally, you cannot waive your rights under the law. The law says that you have a right to cancel, you have a right to get a refund. So unless you have signed something in writing, I would say it wasn't actually a waiver. I'm seeing here a question by Diane. I requested my chargeback in early April. It was put on my credit card. After 60 days, I had the funds transferred to my account from Visa. As it has been over 150 days without being contacted by Visa or Air Transat, I am considering my case closed. I don't want to contact Visa and potentially awaken the sleeping beast. What would I say when contacting my MP, or what would my post on Twitter that would be worthwhile? Diana, I would say that just because you got your refund, it doesn't mean that your neighbor or your friends from this group got their refunds. So what you can say is that there are still hundreds of thousands of Canadians who are owed a refund and haven't received their refund. What is going to be happening with them? Why are airlines getting now some kind of government subsidy, which will be coming now in the form of regional airlines, while actually the passengers have not received back their hard-earned money? Christine is saying, PC MasterCard took 5 months before they put the money back on my card. Does that mean they went against Ontario Consumer Protection? Christine, that's a very good question. Quite possibly, yes, although they would argue that you were not doing a statutory chargeback, but only an internal chargeback. I would say that with the current low interest rates, if they put back the money and if they also refunded you any interest that you may have been charged, if you were charged anything, I would just be happy with the money and move on. These have been with exceptional times. If you have your money now, I would move the money off the card, and if they ever attempt to rebill you, of course, you have to pay. Another important thing is sometimes you get a temporary credit, move it off your card. If they try to rebill you, refuse to pay because it is not a legitimate charge, and you don't pay the illegitimate charges. You only pay those charges that are legitimate. Renan has also a long question. I'm trying to read it. It's a bit long. After a good time, I just got a return from my lawyer from Brazil. Air Canada decided to make a deal to keep it out of court with me and my wife. We sued them in Brazil since we got stuck there because they refused to get us a flight back because it was too expensive to send us from Brazil to Frankfurt and Frankfurt to Toronto, but that was the only route available, and we live in Canada. We first got a court injunction that forced them to get us back home, that they failed to follow the deadlines at first, and we'll pay fines for it until they finally got us a flight back. With that, we also sued them for all extra costs we had with accommodation and whole mental stress caused since they canceled out our tickets at least 3 times and tried to charge us almost 10 times the original amount to get back home. If you still stuck overseas, check with local authorities. The companies have to follow the consumers' laws of the countries where they have a business. So since Air Canada has an office in Brazil and does business there, we were entitled to have them honor that country's law. That's quite true. Renan, thank you very much for posting this. I don't have the technology yet to be able to show the posts nicely on my screen. You can see that this additional logo is even new. I'm working every week to improve a little bit our broadcast. But This is a very, very nice post. Thank you, Renan. Indeed, this is the reason that when you are dealing with the European Union, for example, you would rely on European legislation to get your money back. Carney is asking, I passed the chargeback period with Visa and I was waiting for a credit card insurance to answer my claim, which was refused even after I asked them to relook my claim over, but was denied again. Is there anything else I can do with credit card? And Carmi, I'm not sure in which province you are, but if you are in one of those provinces that have a statutory chargeback, proceed to a statutory chargeback. It's very nice that your credit card refused you on an internal chargeback, but once you switch to a statutory chargeback, they have to comply with the laws of your province. If they don't, just claw back the money from your next bill. Spend down, if necessary, your credit card or move money out from your credit card that is equal in a quantity to the amount that they owe you for a chargeback, and then refuse to pay because you have already paid it once. You should not be paying things twice. If you paid something for your ticket and they are refusing to charge it back, even though the law says they have to do it, then you can offset that claim against your claim, and if they don't like it, they have to take you to court. The point is that you want to turn the tables on those credit card issuers, those banks. You want a situation where instead of you running after them, trying to get your money back from them, they are running after you, trying to get back what they claim to be their money from you. That will be very costly for them, and it's far more simple from their perspective to go to the airline and say, well, you guys have to give back this money. You didn't deliver the services. Miriam is saying, has one more question here. When I called Lufthansa with respect to a refund, agent agreed no problem, but said 6 to 8 weeks for it to come through due to heavy volumes. Does this sound reasonable? Would you suggest that I just wait for this period, or should I be proactive and go to chargeback? Miriam, the law says 15 days for a chargeback. I would not wait more than 15 days. So they have 15 days to issue a refund. And I'm not sure in which province you are, so check your provincial law, of course. But I would say 15 days is a reasonable period for waiting, giving a merchant a chance to process the refund. After 15 days, proceed to a chargeback. Worst case scenario, they issue you a refund in the meanwhile, and then a credit card will see that and deal with that. I think we've pretty much covered our agenda for today. I am not sure yet when we are going to have our next broadcast, because 2 weeks from now, if I'm not mistaken, is going to be Thanksgiving weekend. So I'm not sure, you probably will be too busy with your various turkeys. And I'm not referring to the airline employees or airlines agents or lawyers, but I'm referring to the actual turkey that will be roasting in your oven, hopefully, or some substitute. But probably sometime in October, we will be back with another episode of Air Passenger Rights Update. And in the meantime, we will continue helping you and helping the community throughout the Facebook group. If you are able to help with formatting the information that we have about statutory chargebacks, it would be most welcome. One of the difficulties that, as I mentioned, we have is to divide into small enough bits that it will be usable for most users, people who are not training law. That's an area where help would be most welcome. That's it for now, and we will see each other later this month, or in fact later next month in October. Until then, be safe, keep your social distancing, and take care of your loved ones.